Big changes announced from immigration the last couple of days. If you're going through the green card process and you have children that are about to turn 21 very soon, this rule changes the way we calculate their age in terms of immigration. It's going to impact if they're going to be able to age out or still get the green card with you guys as a family together. In this video, I'll tell you all about the new changes and everything you need to know to save your children and their immigration status in the United States. Hello everybody and welcome back to Immigration Channel. In this video, I'm going to update you about a new policy update from immigration that changes the way we calculate the age of children under the age of 21 to make sure that they don't age out, lose their availability to get the green cards with their family members. These updates are coming back and forth. These changes have been happening for the past 10 years. And this policy is very interesting because if you filed your green card before August 15, it will make a difference about how your applications will be processed versus those of you guys that are filing the green cards after August 15. I'm going to tell you exactly about the policy change, who is going to be impacted, how it's going to work, and give you some real life examples. So make sure you watch this video all the way until the end, especially if you're going through the immigration process, you have children that are about to turn 21, you're worried about it, you want to know what to do. This video is everything you need to know. So first of all, what is the Child Status Protection Act, also known as CSPA? This is an act that's designed to keep families together by freezing the age of the child for immigration purposes if they are under the age of 21 and unmarried at that time. USCIS, the Immigration Service, updated the CSPA calculation rules on August 8, 2025, just a few days ago. And these updates are going to impacting a lot of immigrants, specifically those of you guys that are going through green card in the employment-based immigration. Before 2023, USCIS used the final action dates chart for filing cases for cases involving CSPA children who are about to age out, but allowed filing with the dates for filing chart, and as a result, allowed some kids to age out. In February of 2023, USCIS changed the rules to use only dates for filing charts for when visas became available, and this change helped more kids become eligible. And the reason why is because the dates for filing chart had more availability for filing because the dates become current much sooner. The new 2025 policy switches back to the final action dates chart. And the reason why they've done that is because Department of State always use the final action date chart, and they want to have consistency between USCIS and the State Department. So under this new policy update, right now, they're going to be all using final action dates for determination of when the child age will age out. How do we calculate the CSPA, the age of a child? So let's look at an employment-based case. The age when the visa becomes available minus the time the immigrant petition, in this case I-140, was pending. For example, if a child was 21 and 4 months when the visa was available, they're going to deduct 6 months, the time the I-140 was pending, and now the age of the child is 20 years old and 10 months, which makes him under 21 and he's not aging out. Applications filed before August 15, 2025 are going to use the February 2023 rules. After August 15, the new rules apply, final action dates. It's important for you to remember that. So what can you guys do now? Before we talk about that, if you're here for the first time, please don't forget to subscribe to my channel, click the notification bell so you don't miss any of my videos, and also give us a big like so YouTube will be able to show these videos to more people just like you. And as always, if you need help with any immigration matters, send me a text 619-483-4549 or go to www.immigrationasap.com, leave your details, and one of our team members will contact you ASAP. Now, let's go back into the video. If you are an employer and you have green card cases with family members, make sure that you check and see which kids of these employees are going to be close to aging out and need to take action on this now. If you are an employee and you have kids that are about to become age out, file the adjustment of status before August 15, 2025. Once again, these changes are designed to fix inconsistencies between USCIS and the State Department. The bottom line, guys, is with these changes, you really have to plan when you're going to file for family members, track processing of the immigrant visas, I-140s, and make sure that everything is done correctly and on time to avoid aging out. So don't wait for the last minute. Let's look at a few examples. In which example, number one, a child will be under 21 under this new calculation. So for example, child is 21 years old plus 2 months when the visa becomes available. The I-140 petition immigrant visa was pending for 8 months. How do we do the calculation? 21 years and 2 months minus 8 months, we get 20 years and 6 months. Child is 20 years and 6 months, qualifies. Because CSPA age is under 21, the child did not age out. Example number 2, child is 21 and 3 months on the date when the visa becomes available. I-140 has been pending for 5 months. 21 years and 3 months minus 5 months, we have 20 years and 10 months. Because this application was filed before August 15, 2025, the old rules apply and this kid still qualifies. Example number 3, under the new rules, let's see how it's going to make a difference. Child is 21 years old and 1 month on the date the visa becomes available. I-140 has been pending for at least 3 months with premium processing or not, and this application is filed after August 15, 2025. Let's calculate 21 years plus 1 month minus 3 months. Now we have 20 years and 10 months for the child age. But under the new rules, we are looking at now the final action dates, and that might push the dates even further. And under the new rules, if the final action dates are lagging, which happens often, obviously, this child might age out because the final action dates are not current. Does it make sense how it works? If so, let me know in the comments. And guys, remember, if you have children that are going with you through the immigration process, you have to speak with an immigration attorney when you start, because these aging out rules are very complicated, they're very confusing, and these new changes are going to hurt a lot of children. So please consult an immigration attorney. Send me a text 619-483-4549. Go to www.immigrationasap.com. Leave your details. Let's get this going. Let's save your children from aging out and keeping families together. Thanks for watching my videos. Hopefully it makes sense. And as always, remember that I'm here for you guys. We have a new guide that we are publishing for travel for green card holders. We just released this week, and I'm giving it for free for people who watch my videos. And the link to the guide is in the description of this video. If you're a green card holder, you know who is a green card holder, use the guide and travel safely back to the United States. Thanks for watching my videos. See you next time.